Hey guys, back with another video. On March 8th, there will be a trial for Derrick Chauvin for killing of George Floyd. The reason I want to show you this news clip is they're trying to upgrade his charges to third-degree murder. How do you feel about that? Do you think that he should get a lesser charge? So leave your comment down below. Don't forget to like, subscribe, and I will see you in the next video.
Minnesota Court of Appeals has scheduled oral arguments for Monday, March 1st on the state's appeal to restore third-degree murder charges against Derrick Chauvin. Chauvin is the former Minneapolis police officer charged with second-degree murder and second-degree manslaughter in the death of George Floyd. Jury selection for his trial is scheduled to start March 8th. So there is a need to get this expedited. And we, of course, have gavel-to-gavel coverage slated here on Court TV, starting with jury selection on the 8th. Before we get to Wisconsin, let's bring back our guests here. We're also joined by Marcia Minot. Josh Schiffer is still with us. Marcia, thank you for joining us today. The Court of Appeals is saying, all right, we'll listen to it. The state wants third-degree murder charges reinstated. The judge said no. Now it's going to be up to the Court of Appeals. The timing here is pretty tight. March 1st, oral arguments. March 8th is jury selection. What's your initial impression about the Court of Appeals saying, yeah, we're going to listen to it, bring on your oral arguments?
Well, the Court of Appeals has an opportunity to decide whether or not the trial court improperly dismissed that charge. And that's a decision that they can make in a pretty quick manner because it's a legal issue, not a factual issue. So once they decide on that date if that charge should be added back in, it will be pretty simple for the defense and the prosecution to pursue their case as it pertains to the charges.
And Josh, this, it's kind of legalese. It's into the weeds here, inside baseball, however you want to qualify it. It's some would say legal mumbo jumbo. But what the bottom line is the state wants this opportunity to have third degree also on the menu for Derrick Chauvin, if you will. And the trial judge in this case, saying it doesn't apply. The facts don't apply to this, and that's why he said that no, it shouldn't be here. What is your take on this and the net effect, and what maybe do you feel like is really going on here? Is this the state just desperately needing all choices for jurors at the end of the day when this trial's over?
Well, I think you've got a bunch of different competing interests, and you're right that this is going into the legal weeds because the functional part that needs to be focused on is actually not this case. It's another case and another ruling that just came out that would support the third degree. And everybody's waiting to find out how the Minnesota Supreme Court is going to interpret that, or whether some more process needs to take place. And the state certainly has an interest in the appeal in prosecuting Officer Chauvin, that they want to apply the third degree murder. This is a legal issue. It is about how the courts work and the rules. There's no facts involved, as was mentioned. So this can be dealt with quickly. And I won't be surprised if the court finds a way to give the state as much flexibility in charge determination as possible. Remember, we've got the backstop of a jury. If the state doesn't prove the charge, the jury's not going to convict. There's also rules on judges having to consolidate lesser included charges and things like that. So this is some legal mumbo jumbo, and it's not going to stop this trial from going forward. That's what we really need to concentrate on, is Minnesota's going to get us some justice.
Well, Marcia, could it, though, delay this trial if the Court of Appeals says, well, we kind of need to hear from the Supreme Court on this? Could the state say to the judge, hey, we need this litigated before we go to trial? Because, frankly, the state and Chauvin both want a continuance in this case, and it was denied by the judge. The state said COVID was the reason, but the judge said, no, we got to plow through here. We want this thing to start on the 8th. What's your take?
To answer your question, yes, it could delay the trial, because if the Court of Appeals decides that we need to hear from the Supreme Court, or we do need to consider a recent ruling, and if we make a ruling and the state makes an appeal to the Supreme Court from the Court of Appeals, that's definitely going to delay the case, because the dates of the starting of the trial are so close to the actual Court of Appeals hearing that matter. I also believe that the Court of Appeals is going to rule in favor of the state. And the reason is because, as co-counsel just said, the state has the opportunity to prove the case beyond a reasonable doubt at trial. If the jurors find that the evidence is insufficient, the jurors can find Chauvin not guilty. The court also has the opportunity where it's called a judgment notwithstanding the verdict. So you can move for a directed verdict. When the state rests, the defense can move for a directed verdict stating, Judge, they haven't proved count 1, count 5, whatever counts they believe was not proven. And the trial court still has the opportunity to dismiss those counts before the jury even hears the evidence. So yes, to answer your question, I do believe it will be delayed if the Court of Appeals says we have to hear from the Supreme Court, or if the state appeals the Court of Appeals decision if it's not in their favor.